Supreme Court recently granted two applications to lift lower court injunctions. Trump v. American Federation of Government Employees, AFGE, involving Executive Order 14210, and McMahon v. New York, involving Executive Order 14242. This allows the administration for now to move forward with large federal workforce cuts. What's especially notable is how the court's liberal justices split on these cases. In AFGE, Justice Sotomayor joined the majority in lifting the injunction, while only Justice Jackson dissented. But in McMahon, all three liberal justices dissented, with Justice Sotomayor writing the dissent. Why the difference? The key distinction lies in the content of executive orders. Under the Constitution, Congress has the power to pass laws, and the president is responsible for enforcing them. Executive orders are not laws themselves. They are directives about how the president will implement existing laws. If there's a conflict, a statute always overrides an executive order. In AFGE, Executive Order 14210 simply directs agencies to plan reorganizations and reductions in force consistent with applicable law. On its face, it doesn't conflict with any statute. As Justice Sotomayor wrote in her concurrence, the plans themselves are not before this court, and we thus have no occasion to consider whether they can and will be carried out consistent with the constraints of law. In other words, the majority, including Sotomayor, found it premature to block the administration from even developing such plans. By contrast, McMahon v. New York involved the Department of Education, a cabinet-level agency that Congress created by statute. Executive Order 14242 had the explicit goal of abolishing the department, which directly conflicted with federal law. The executive order's operative section was titled Closing the Department of Education and Returning Authority to the States, and it directed the secretary to take all necessary steps to facilitate the closure of the department. Consistent with that directive, Secretary McMahon publicly vowed to oversee the department's final mission, effectively eliminating it. Justice Sotomayor concluded this was unlawful on its face because only Congress has the power to abolish a cabinet-level department. In short, Sotomayor did not view Executive Order 14210 as clearly violating the law, while she saw Executive Order 14242 as doing exactly that. Finally, it's important to remember these Supreme Court orders aren't final decisions on the legality of the executive orders. The lower courts can still review them on the merits, and some of these cuts could ultimately be found unlawful later.